Welcome everyone to this panel on Indigenous peoples and the Constitution. We have an amazing panel this morning, and we're going to hear them all before we get to ask questions. Panelists have about between 10 and 15 minutes. And we're going to start, as Bruce said also earlier this morning, you have access to the more detailed bios on the website. So I'm just going to quickly introduce our panelists. Our first speaker this morning is Senwin Look, who's with Althuis Clear and Townsend. He's going to speak about the jurisprudence relating to title that has moved a lot in the recent months, and for which, as you know, we're awaiting a Supreme Court decision soon in the William case. We're going to follow with my esteemed colleague, Professor Slattery, that a lot of you know here at Osgoode Hall, who's going to speak to us about the Manitoba Métis Federation case and the honor of the Crown developments by the Supreme Court in that decision. We're going to follow with Michael Burke, who's counsel with the Crown Office Civil at with the Attorney General for Ontario, who's courageously stepping in for Malia Wilson, who was here just moments ago but had to be was called away. And he's going to talk about federalism in Section 35 and the role of the provinces in that conversation. And we're going to end today with Jeffrey Hewitt, who is this year the Osgoode McMurtry Fellow, as he's completing graduate work, finishing his LLM here at Osgoode, and who's also the General Counsel with the Chippewas of Rama First Nation. And Jeffrey is going to speak to us about his paper, Reconsidering Reconciliation. So, thank you very much.
Okay, thank you everyone. Thank you to the conference organizers for putting together such a great event. I am honored to be on this panel with such distinguished colleagues, and also honored to be on the traditional territory of the Mississaugas of the Credit First Nation, as well as a site where people who are antecedent to the Huron used to live. Right underneath the power lines that are just over there, there's actually an old village that's buried underneath there. I didn't know that, and I went to York for 3 years for law school. So that's okay. So in the interest of time, I'm going to just go through this initial part pretty quickly here to talk about Aboriginal title. So this is the familiar picture, in a way, of what Aboriginal title looks like in Canada. So you see the colored parts indicate where land where treaties have been signed to cover that land, and there's white parts. Now, the white parts are not blank because nobody lived there. The white parts are blank because the Crown didn't bother to sign treaties with respect to those lands. So this basically shows the two models of, grossly oversimplify, two models of how a colonial power can deal with Indigenous land rights. You can either pretend that the people don't exist, or you can acknowledge their rights by signing treaties with them. So if you pretend that they don't exist, this is what international lawyers would call terra nullius. You say that the land is empty, and you just assert that by colonization, everyone else's rights are deprived. So what this picture shows is the treaties, but also the blank spaces, and the blank spaces are places where Aboriginal title litigation, which is the use of courts, use of litigation to prove title, is the most important. So just to situate the case that I'll be focusing on today, if you look at, there's no laser pointer, but sort of smack in the middle of the blank space that's British Columbia. That's the traditional territory of the Chilcotin Nation. And they are the plaintiffs of the case that was under litigation that is now or was before the Supreme Court of Canada in November 2013. So just briefly, the Crown arrived around the mid-19th century. There was never a treaty with them, and they started litigating their title claim in the late 90s after Delgamuukw. And in 2007, the BC Supreme Court, after I think a year and a half long trial, decided that the pleadings of the Chilcotin Nation had described a certain claim area, but the judge had found that a slightly different claim area could be made out. And the Crown complained that they were prejudiced by the difference between the pleadings and what the evidence would have resulted in the finding of. And they succeeded in that pleadings point. And so the trial judge spent about 20 paragraphs talking about pleadings and said the case is dismissed, but spent another 400 or so paragraphs giving an opinion of what title could be made out in the area and encouraged the parties to go back and negotiate. And you wouldn't be surprised to find that the negotiations didn't get anywhere for 2 years. And so there was an appeal to the BC Court of Appeal, which was decided in 2012. And that's the decision that I would like to focus on. So at the BC Court of Appeal, the Chilcotin Nation decision became renamed the William decision after Chief Roger William. And the main debate, so the BC Court of Appeal threw away the holding of the trial judge with respect to pleadings and focused solely on the Aboriginal title issue. And the main debate was about the difference between what the parties called a territorial conception and what is called a postage stamp conception of Aboriginal title. And what the BCCA said was that the territorial conception was quote unquote antithetical to reconciliation. So what's the difference, or what is it? What is the postage stamp view? Well, I think it's quite well articulated in paragraph 221 of the BC Court of Appeal decision. I'll focus on the underlined parts. So Justice Groverman held that he thought that in litigation for Aboriginal title, what should be capable of being found as Aboriginal title were little spots of intensively used lands. And he says, examples might include salt licks, narrow defiles between mountains and cliffs, particular rocks or promontories used for netting salmon, or in other areas of the country, buffalo jumps. Okay, so in my view, this is quite a dramatic statement with respect to the concept of Aboriginal title. What does it say about the areas of the land that are outside of salt licks and buffalo jumps and salmon rocks? Well, I would suggest that the result is that conceptually there's terra nullius there. So, I just would like to go back a little in history and situate where the BC Court of Appeal's conception of Aboriginal title fits within a bigger picture. So just go back to Worcester versus Georgia, one of the landmark decisions of the US Supreme Court back in 1832 by Chief Justice Marshall. And he says, the extravagant and absurd idea that feeble settlements made on the seacoast, or the companies under whom they were made, acquired legitimate power by them to govern the people, or occupy the lands from sea to sea, did not enter the minds of any man. So the question I would pose is, to what extent does the William decision in the BC Court of Appeal return us back to this extravagant and absurd idea? This statement applies just as well to British Columbia. By establishing settlements in Victoria or Vancouver, did the British Crown thereby acquire title, the right to occupy lands, right? The title to all of British Columbia. So obviously the US Supreme Court said no to that question, and the model that they came up with for reconciling these positions was that discovery only gave the Crown the right to exclude other European powers, and to deal with Indigenous nations exclusively. And that has been the position of the British Crown in Canada, by and large, since the Royal Proclamation of 1763. That's why there are treaties between the Crown and First Nations. So the treaties, unless there is a treaty, the First Nation is entitled to exclusive occupation of the lands, unless they have consented to not be on those lands anymore. That's what treaties are about. And British Columbia is an exception. It's an exception because it was Crown policy to treat it as terra nullius. There were memos going back and forth from Ottawa to Victoria saying, you guys really gotta do something about Aboriginal title and sign some treaties. And then you can see the BC just ignores that. So it's really a problem that is created by Crown policy. So how is Aboriginal title dealt with in these treaties? So I think it's quite clear, and I argue this in the paper, that the conception of Aboriginal title in the treaties is clearly territorial. You look at Treaty 3, the text of Treaty 3 itself says that the lands being dealt with total 55,000 square miles. I don't think you can, in the entire continent of North America, find enough salt licks to equal 55,000 square miles. Treaty 8, as read by the Supreme Court in the Mikisew Cree decision, says, they interpret Treaty 8 as having dealt with 840,000 square kilometers. Obviously, it's another instance of the territorial conception. And I actually did a fun text search of historic treaties, and I can tell you that the words Salt Lick, Salmon Rock, and Buffalo Jump are never used. Okay. And not only is this a picture of title in historical terms, but modern treaties, such as the 1999 Nunavut Treaty, or the 1984 Nunavut Treaty, or the James Bay Treaty of 1973, all of these deal with large areas, territorial conception. So how did we end up in this slightly different position with respect to litigation? So in 1997, the Supreme Court finally recognized a way for Aboriginal communities to prove Aboriginal title through litigation. And they said that you can prove title if you can show that at the time of the Crown assertion of sovereignty, that the community had exclusive occupation. And you can show exclusive occupation in one of two ways. The first way is you can show that the laws of the Indigenous legal order of the community that's presenting the litigation dealt with the land. And second is you can show physical occupation. So in 2005, the Supreme Court applied the Delgamuukw test for the first time because, well, so we'll leave that aside. Okay, so it was a criminal prosecution for cutting timber on Crown lands, and Aboriginal rights and title were raised as defenses. And the Aboriginal title defense failed after the majority of the Supreme Court only applied the physical occupation branch of the test. So now we're at William in the BC Court of Appeal in 2012. Once again, they only applied the physical occupation branch of the Delgamuukw test, and it was applied in the restrictive manner that I discussed earlier. So now the William decision is on reserve at the Supreme Court, and what will they do? Who knows? Okay, so what does this mean for Aboriginal title and reconciliation more generally in Canada? Is terra nullius back? And whatever happened to the proof by Indigenous laws branch of the Delgamuukw test? So I would suggest, the argument in my paper is that true reconciliation has to involve the recognition of Indigenous legal orders. And the focus in the BCCA on hunting and fishing activities of Aboriginal peoples effaces their continuing existence as spiritual and legally ordered communities. So what do I mean by that? Well, I'll just give an example. So consider that it is a commonly accepted norm of Anishinaabe law that burial sites are not to be disturbed. Okay, so how do you apply a physical occupation test to an area that is not meant to be disturbed? Well, you're not meant to go there, so clearly no one goes there. Does that mean that it was not important to you? Does that mean that you should have no rights to regulate what happens to that land? Contrary-wise, I would suggest that a burial site of an Aboriginal community is the par excellence example of land that should be regulated by an Indigenous community itself. And I think that the Indigenous law branch of the Delgamuukw test for proof of title is an excellent opportunity for recognizing this kind of norm. So I have 1 minute left, so I'm going to just go through this quite quickly. And as, Marshall and Bernard suggested that we should look to common law to see how Canadian law can recognize Aboriginal laws. Well, so I looked at the English law on burials, and I didn't know this until I did this research, and we don't really learn this in law school. Until the mid-19th century, all Christian burials in England were governed exclusively by ecclesiastical law. Nowadays, ecclesiastical law still governs old burial grounds and new burial grounds that are established by the Church of England. So they have their own ecclesiastical courts. They can declare any land in England to be consecrated ground. By this declaration, the jurisdiction of the common law courts is ousted, and the land remains consecrated unless the declaration is reversed by the ecclesiastical court itself. This means that the lack of physical occupation will not lead to the reversal. So picture of, this is a town in England called Charlbury. I think that churchyards are very nice. They're nice places to visit. As a result of ecclesiastical law, the British economy has not exactly ground to a halt. And the common law is perfectly capable of living and growing alongside a parallel legal system in England. So why not in Canada also? It's not, I would say, just to clarify, it's not necessarily confined to sacred sites of Aboriginal communities, but should include the recognition of other types of Indigenous land laws as well. So to conclude, I would argue that the law of Aboriginal title in Canada contains this germ of a possibility of true reconciliation, which is the recognition of Indigenous legal orders. And it really is the only true way that the Canadian legal system can reconcile itself to the prior and continuing occupation of this land by legally ordered human communities. Okay, thank you.
Some sharp-witted individual said that the louder someone starts talking about their honor, the faster you better start counting your silverware. And perhaps we should start counting. Because in the Manitoba Métis Federation case, the Supreme Court of Canada elevated to a status of overweening constitutional importance the doctrine of the honor of the crown, which previously had played a role, albeit somewhat of a background role, in the interpretation of the guarantee of Aboriginal and treaty rights in Section 35. Now, the detail of the case is simply that the court ruled in the end that the Crown had failed to diligently implement a promise undertaken to the Métis people with respect to land in Section 31 of the Manitoba Act of 1870. And they held that that failure violated a branch or an application of the principle of the honor of the Crown. And they held more generally that the principle of the honor of the Crown requires the Crown, in the context of its relationship with Aboriginal peoples, to interpret its promises to Aboriginal peoples in a purposeful way and to fulfill those obligations diligently. Hence its ruling that the Crown had failed to do this in the context of Section 31 of the Manitoba Act. I'm going to comment on two aspects of this decision that I find particularly interesting. The first is the constitutional status and significance of this common law principle of the honor of the Crown and the relationship that it bears to the ordinary laws, be they common law or statute. And secondly, I'd like to say something about the position that this principle occupies in the broader constitutional scheme that makes up our Constitution. When I reread Manitoba Métis Federation in preparing for this talk, I was struck by something that I must admit I had failed to almost notice previously. And that was that the court uses a common law constitutional principle, not embodied in written form anywhere in the Constitution, to override validly enacted statutes of limitations. And yet that is precisely what it does. It holds that statutes of limitation, in particular those enacted in Manitoba, which would in effect have ruled out any possible claim, even declaratory, as against the Crown in this context, were inconsistent with the basic constitutional principle at stake, namely the principle of diligent performance of constitutional obligations. And as such, the court could not be prevented by, what the court says, mere statutes from ruling on the constitutionality of the Crown's conduct. If you read the passages in the Supreme Court's majority decision, and if you compare them with the rather acerbic comments of Justice Rothstein in dissent, it becomes reasonably clear that this is precisely what the court is doing. That is to say, it is using a common law constitutional principle, unwritten, to override statutory limitations enacted by a legislature. To some extent, the Supreme Court, in its majority decision, fudges the point, because in the relevant passages where it holds that statutes of limitations do not apply, it invokes written constitutional provisions along with the constitutional principle at stake. The written constitutional provisions that it invokes are Section 31 of the Manitoba Act of 1870, which was constitutionalized by a statute passed by the United Kingdom later, and secondly, Section 35 of the Constitution Act of 1982. And yet, if you look at what the court is holding precisely, it's not holding that the statutes of limitations were inconsistent with a section of the Manitoba Act or with Section 35. That's very evident in the context of Section 35, because had that been what the court was saying, it should have gone through all of the Sparrow test, with the test for infringement and justification, asking whether or not these statutes of limitations actually did infringe an Aboriginal treaty right, and if so, could it be justified? It doesn't do it at all. What it is holding is that the Crown's conduct is unconstitutional, and it's unconstitutional because it violates an unwritten constitutional principle. What is the upshot? I think the upshot is that the court is taking this principle very seriously indeed, and this is not the last time when we're going to see the court using it. We're going to be seeing it, I think, in a variety of different contexts that would not necessarily ordinarily come under Section 35. So that's my first point. My second point relates to the position of this unwritten constitutional principle in our broader constitutional scheme. Of course, in Manitoba Métis Federation and in the cases which preceded it, the court is using this principle exclusively in the context of Aboriginal peoples. This principle, they say, is embedded in the fundamental relationship between Aboriginal peoples and the Crown that stem from the encounter, the historical encounter between sovereign Aboriginal peoples on the one hand and the sovereign British Crown, or perhaps French Crown, coming in. Is this principle then some kind of constitutional anomaly? Or does it fit somewhere in our broader constitutional scheme? And here I'd like to call in aid a passage from the separate opinion of Justice Deschamps in the Beckman-Little Salmon-Carmacks case decided by the Supreme Court of Canada in 2010. She says there that this fundamental relationship, or pact, as she calls it, between Aboriginal peoples and the Crown is one of three such compacts that underpin, in effect, confederation. The two others relate respectively to the provinces, on the one hand, and secondly to individuals, And that second one relates to the Charter of Rights and Freedoms. So, she says, in the end, we have three basic compacts underpinning Confederation. This is in paragraph 97, for those who'd like to take a look at it. Three basic compacts, one relating to Aboriginal peoples, another relating to individual citizens of Canada, embodied in the Charter of Rights and Freedoms, and third, relating to the provinces, and that in effect is the scheme of division of powers in our federation. Now, she comments that the doctrine of the honor of the Crown relates particularly to this pact between Aboriginal peoples and the Crown. What I would like to suggest is that the doctrine of the honor of the Crown, in effect, in some form or other, permeates all three of these compacts. That the doctrine of the honor of the Crown is an application of a broader conception of constitutional trust, which underpins our Constitution as a whole. That trust, as the Supreme Court noted in the secession reference, is shot through with other basic principles, such as the principles of the rule of law and constitutionalism, the principles of federalism, democracy, and respect for minority rights. To that, they add the principle of the honor of the Crown. And I'd like to say that all five of those principles, in effect, apply to these three basic structures that make up Confederation. Now, you can view that as kind of a theoretical point, or a point that somehow adjusts certain conceptions of the Constitution. But I'd like to put a little bit more weight on it and suggest that the Supreme Court is gradually moving to a position where it is recognizing Aboriginal peoples as a third order of government in Canada, holding, yes, a special relationship with the Crown, but so indeed do the provinces hold a special relationship to the Crown, and so indeed do we all as individual citizens. Thank you very much.
Well, as Andre says, I am not Malha Wilson, and I'm not the the Assistant Deputy Attorney General of Ontario. But it is my honor to be here today on Malha's behalf. She wished me to pass on her apologies. She was here up till about 10 minutes before the beginning of the session and then was called away for an emergency. So I have the honor to stand in her shoes, and I'll do my best on such short notice. I assisted Malha in getting ready for today, and the paper that was submitted for the conference deals with primarily two decisions. One, my friend spoke of earlier today, and that's the Chilcotin or the Roger Williams case. But rather than looking at the Aboriginal title aspect of that decision, we've looked at a secondary component which related to sort of interjurisdictional immunity and the federalism issues in that case. The second case that we looked at in the paper is a case called Keewatin versus the Minister of Natural Resources. And you may not have heard of it if you're not following Ontario Court of Appeal decisions. It's a decision which has not yet been argued. It's scheduled to be heard on May 15th of this year. And it involves a similar theme to the federalism issues which were in the Roger Williams case. So since there weren't too many cases in 2013 dealing with Aboriginal rights, I think apart from Manitoba Métis and maybe a decision called Bain, we thought we would look at cases that haven't yet been decided, but that are on the books and may, perhaps our discussion will foreshadow where the courts may go or the options available. So I was a graduate of Osgoode, and I think I may have been in this class for my Aboriginal Rights 101 with Professor Amai. And the first thing I learned was that under Canada's Constitution, the federal government has exclusive federal jurisdiction for Indians and the lands reserved for Indians. And of course, the next thing we learned was that the provinces have jurisdiction in relation to crown lands, timber, the management and sale of non-renewable resources such as energy, mining, etc. Now, I think when the Constitution was first drafted, those may have seemed like exclusive realms, but as the years have gone on, we've come to discover that there really is no exclusivity between them. How do you separate Indians and lands reserved from Indians cleanly from the Crown, the provincial Crown's rights over Crown lands, timber, and resources? And I think as a result of the fact that there's this sort of inherent overlap, the courts have been struggling in recent years with just what is the role of provinces in our federal structure? How do provinces relate to First Nations? And how do Section 35 rights interplay with the division of powers in Sections 91 and 92? And Section 109 of the Constitution, which is the section that provides provincial governments with the ownership of Crown lands. So what we've seen in the Roger Williams case at the lower levels and in the Keewatin cases is that there has been a movement, I would say by the First Nations and Aboriginal Council, to encourage the courts to move towards an approach to Section 35 rights that would see the federal government in a sort of mediating or intermediary role between the First Nations and provinces. And the theme in our paper is that a true reconciliation of Crown sovereignty with Aboriginal peoples and reconciliation of Aboriginal interests and non-Aboriginal interests would be an approach which involves a careful consideration of our federal division of powers, including the rights of the provinces in that picture. So in the Chilcotin decision, the secondary issue had to do with whether or not the British Columbia's Forestry Act could apply on Aboriginal title lands. And the position of the Chilcotin was that it could not apply, and it was based on the principles that Aboriginal title lies at the core of federal jurisdiction under Section 9124. That pursuant to the doctrine of interjurisdictional immunity, the provinces cannot impair the core of federal jurisdiction, even through incidental effects of otherwise valid laws of general application. And that for this reason, provinces could not impair the use or the possession of lands reserved for the Indians, which would include reserve lands and title lands. And the Chilcotin relied in part on the decision of R.V. Morris. So Morris and Olson was the night hunting case out of British Columbia, in which the Supreme Court of Canada, after finding that a regulation which prohibited night hunting was a prima facie infringement of the Sartlip's Section 35 rights, the Supreme Court went on in that case to say that as a result, it impacted on the core of Indianness, the core of federal jurisdiction over Section 9124, and that it could never be saved or could not be saved through the Sparrow and Badger justification test. So the Chilcotin have relied on that decision. The Crown parties and interveners took a different approach and were really beginning to try and push back on the Morris decision. The issue, I think, for the provinces and for the federal Crown was that where you have a situation where a prima facie infringement of a harvesting right or a Section 35 right automatically moves you into the realm of an impairment of federal core jurisdiction over Indians and lands reserved for Indians. You're in a place where principally most, or I would say a great significant where many of Crown decisions relating to lands and resources are automatically going to hit on a treaty right. And you can't take up land, you can't develop a subdivision or build a road without having some impact on a harvesting right. So the concern with the Morris decision is that if any infringement or any impact moves you within the realm of impairing Section 35 rights, our province is in a place where they are being straitjacketed. Or do they still have constitutional room to operate in the public interest with respect to their Section 109 and their Section 92 jurisdictions? One of the submissions of the Crown Counsel in the Chilcotin case is that we have today two lines of jurisprudence. One is the Section 35 duty to consult jurisprudence, really under Haida for Aboriginal rights and Mikisew Cree for treaty rights. Under that line of cases, the Crowns are required to consult and accommodate with First Nations and Aboriginal peoples when they contemplate decisions which may have an adverse impact on an Aboriginal right. And through this duty to consult, we've seen a lot of development. We've seen impact benefit agreements negotiated. We've seen an increase in the involvement of First Nations in decision making that affects their lives and their traditional lands. The second line of jurisprudence is the one I alluded to earlier, which is the interjurisdictional immunity approach. And this is the approach where you have a provincial action or statute which has an impact or impairment of a Section 35 right. You move beyond the ability of provinces outside of their, you move into an ultra-virus realm. The Keewatin decision involves somewhat similar issues, but in a treaty context. The Grassy Narrows First Nations, which is a First Nation in northwestern Ontario in Treaty 3 territory, has argued in that decision that the words that the Dominion of Canada in that treaty's taking up clause mean that it is only the federal crown that can take up lands within their traditional territory. And at trial, Justice Sanderson of the Superior Court Justice accepted this position, and she held that what exists in the Keewatin territory is a situation where if the Crown and Right of Ontario would like to take up land for forestry purposes or other purposes, it can do so, but only if it first obtains the approval of the federal government. And the federal government acts there in a sort of a protective role, an intermediary role between the Treaty 3 First Nations and the provincial government. So it's a tie back to the position which was taken by the Aboriginal parties in Roger Williams, that the federal government must be in sort of a mediating role between provinces. We don't yet know how the court will approach this, but it's interesting that they've taken up to here two cases with similar issues, and I think that it'll be an exciting year to see how this issue plays out. I know it has caused, there's a lot of questions within government, and I think probably outside of government, as to how far and to what extent provincial laws will apply. And I think that this 2014 should be a year where we hopefully will get a few answers to this question of the way in which Section 91 and 92 relate with Section 35 rights and provincial powers.
Hi there. So when they first told me that I had 10 minutes to talk to you, I thought, it usually takes Aboriginal people about 10 minutes to introduce ourselves. So always being up for a challenge, we'll roll with it. So first I want to say thank you to the Anishinaabe who allow us to live in their territory and bring us together in places and spaces like this as our hosts. And as a Cree man who lives in this territory with my children, I also want to say thank you to them for the reminder of what it means every day to share. I also want to thank the organizers for today and giving us all a chance to come together and the insights that all of the panelists have offered us. I am going to talk about the Ben case, Bain, tomato, tomato, which is not to be confused with Ben Berger, though I will probably talk about you for 10 minutes or so in a reconciliatory good way. So I'm going to get started. I've chosen the image on the screen behind me. It's meant to be sort of a stylized wave, but also from the image, I see our Thunderbird here, with its beak to the side and the wings spread open, and both the water, the waves of the water, and the Thunderbird carry tremendous power with them. And I thought that was an important message or visual to think about as we consider or reconsider, as the case may be, reconciliation. So I'm shorthanding a lot because you are who you are. You know the content of Section 35. I've included the Black's Dictionary definition of reconciliation as well. I thought it was interesting to take a look at what it means, which is a restoration of friendly relationships, which when you have the Crown who has asserted sovereignty in a way that there in fact wasn't a war, those relations at the beginning were friendly. How do we get back to that place? Or in the alternative definition, we're looking at the action of making one view compatible with another. I've drawn a quote down from Delgamuukw from Chief Justice Lemaire. I'm not going to read the entire thing. I am going to just talk about the last little bit, though, where he says in Delgamuukw, let's face it, we are all here to stay. And I think that's an important piece because what it tells us is we actually need to reconcile. It's not really an option if no one is going anywhere. I've drawn for you a relationship which I see in my mind, and I like Prezi simply because it lets me show you how I see things, though as I've noted before, I don't quite in my head see things as high def as Prezi is. But if we talk about or group together in rings some of the ideas around the doctrine of honor and those cases that we get, that articulation that comes out in Sparrow, the re-articulation in the cases since, Manitoban Métis case and Lax Kw'alaams, which I'm going to talk about briefly, technically not a constitutional case from 2013, but I'm advised it wasn't dealt with in previous constitutional gatherings here. And then the duty to consult, which we get articulated in Delgamuukw, and then again in Ben, though in a funny sort of way, because that case is more about a procedural issue than it is a Section 35 claim. So Lax Kw'alaams, let's take a look at this for a minute. Here we have a First Nation seeking a commercial right, or arguing a commercial right to fisheries, large-scale fisheries. Unlike some of the early articulations we see in Lax Kw'alaams, the First Nation is actually framing the case. So this is not coming from charge of an existing regulatory regime. And what we hear or get back from the court is, probably should have framed that a little bit better, and I tend to agree with that. One of the things we have at issue here is that there is this honor of the Crown question, and whether there is a right, which is what they were asking, to accumulate wealth through a commercial fishery. And is that contained in Section 35? We get a reaffirmation of Vanderpeet, which in a short sentence means you got to prove it was your way of life, but the way of life has to be distinctive. It can't simply be you harvest fish for food because all societies need to feed themselves. There's nothing distinctive really about that part. We also get this 4 elements that the court start to lay out toward the end. And the last one, we really need to be fair to the economic and regional interests of industry and non-Aboriginal Canadians. So when we ask, or when I ask, what does this have to do with reconciliation? I think what we're being told is that even though all societies need to eat, not all societies have access to the accumulation of wealth. That's being reserved for someone different. When we come to Ben, We're looking at logging permits that were issued. The First Nation, Fort Nelson, raised issues and concerns that they had about the duty to consult and about particularly lack of funding around how they went through their consultation. Ultimately, the Ben family protest when there are 2 permits for logging that are issued within tracks of their trapline. So they stop this by standing in front of the machinery from Moulton as they come moving in. What we get from the court, though, is this question about a motion to strike. Because what comes up from Moulton is, gee, we got these permits from the Crown. You cannot, as a family, the Ben family, representationally of the First Nation, hold or argue the duty to consult was breached for you particularly. Though in the decision the court does say, because it was the Ben family trapline, they may be disproportionately impacted by the decision to issue these permits. What we're told back, though, is the right way to have gone about addressing the issuance of the permits was through a judicial review process, not the self-help, i.e. blockading, that the Bens engaged in. Ultimately, it was also found to be an abuse of process. The family should have gone through the aforementioned process to claim invalidity of the licenses. So the court actually never answers the question on validity. You'll see in the upper corner in orange, in December, just before the break, because this was a procedural issue, ultimately on the merit, Justice Saunders in BC decides, gee, there is a problem here, and then awards $1.75 million to Moulton, because the licenses that were issued, and by the way, that was against the Crown, not against the First Nation, because the licenses that were issued had what he called an implied consultation promise. In other words, this has cost Moulton money, this protest, this litigation. What I want to draw for you out of Ben, and there's a lot to say about this case, but in particular what I want to draw out from it, as we think about reconciliation and who is coming to the table, one of the pieces of the discussion that the court doesn't answer because ultimately they decide this is an abusive process is who has the representational right to assert and argue breach of a duty to consult. Is it the First Nation elected leadership under the Indian Act? Is it the grassroots people? Is it a family or group within a First Nation community that may be more disproportionately affected by a decision or a granting of some license or harvesting permit? Who carries that? When we talk about the collective versus the individual, there are submissions that are made. Interesting, one of them comes from the Fort Nelson First Nation, who says, gee, you know, kind of 3 bundles of how we deal with our rights. We have collective that are held collectively, we have collective rights that are held individually, and we have different obligations to our families, to ourselves, to our nation, to our clan or dotem. Ben seems to tell us the proper place or the proper group to do that should be chief and council who've been elected under the Indian Act. This is going to play out in our communities in a very troublesome way. Who is representative of holding our rights? Who comes to the table? Who can assert those rights? How do we deal with the next, I think, grading up against with this decision when chief and council disagree with idle no more? When we have more people who are protesting against and asserting a collective right than we do who have been elected to do that, how do we decide who has the right to say we weren't consulted, the Crown has breached its obligation? Who gets to sit at the table? The good ones that we recognize because they went and got elected under federal statute? Or the grassroots people who may have a differing view? I'll just briefly summarize what I think the court might be telling us here. And I'm not all negative about it, but it may sound that way. Economic interests for non-Aboriginal people prevail when there is a conflict. This is what I'm drawing out of Lax Coulombe's. Collective rights need to be asserted by elective individuals. But at the same time, the court is saying we have an interest in resolving these things. Section 35 is about reconciling our relationship as a country to Aboriginal people. How are we going to go about doing that? Well, as we've seen in Delgamuukw, series of cases in between, and the last iteration of it in Manitoba Métis is, look, you need to negotiate reconciliation. So what might that look like? Is it a hierarchy of rules? Is it a playbook that we keep seeing coming out of the court saying, no, this is what we meant by honor of the crown, and now we have to correct you again. This is what we meant. Did you not hear us the last time? This is what we meant. Now you need to consult and accommodate, and oh, here's what we meant by that. It doesn't include a right to veto, but it does include these other things, right? So what I want to finish with is to say, if reconciliation is being defined by the courts hierarchically, that is one way to bring us all to the table to decide how we're going to resolve our differences, how we're going to reconcile and restore our relationship. But the bird sometimes in its beak carries gifts, and sometimes the crest of the wave holds something that we just anticipate coming toward us. And here I would say this is something for us to consider around reconciliation. What you have on the screen behind me now, screens, is a petition that was drafted by the Chippewa people, the Ojibwe. And what it says, this was from 1845, 47. In your left, what looks like some blue kidneys is in fact being read this way. We are the people of the lakes. We stand together. We are the catfish, the mer people, the muskrat, the beaver, the crane. We stand behind the one who speaks to you and carries this. We have consulted each other. We have spent our time drawing each other together with the common message. We tell you this because we are drawn together with one mind as we connect through our eyes. We have one vision. The one who stands in front sees forward. We have come together well, and you will know this because we are connected by the heart. One mind, one heart. Hear the one who speaks for us. We have chosen him well through this process. This tells us some things about reconciliation, does it not? Do we come to the table on one side with our hierarchical ideas, our rules and our playbook, and our advantage of the Supreme Court decisions backing us up? Or do we come with good minds and good hearts? Do we go through an internal process where we decide how we're going to come together and what reconciliation means? Maybe it means we share a good mind. We are connected with one vision. We have come together with good hearts, and we have chosen one to speak well on behalf of all of us, and this is who we are. So I offer that up to you today as another way of considering or reconsidering, because this isn't new, how we're going to come to the table together, how we're going to find a way through our Constitution to reconcile the relationship between Canada and Aboriginal people. With that, I think I'm just under my 10, and I say to you, hi, thank you very much.
To the panelists, we have just about 10 minutes for questions with the use of this symbolic looking microphone. So if anyone wants to start, if you could introduce yourself.
Okay. Hello, Lisa Kerr, New York University. So I was very interested in these final questions around the collective and the individual, and who should get to advance these claims. And I wonder if the panel, perhaps Professor Slattery, could comment on how standing is an issue in the Manitoba Métis case, and it's arguably the first big application of the Supreme Court's holding in the Suave decision around public interest standing and ensuring that collectives have the ability to have their interests heard. And I'm wondering if the new law of public interest standing might answer some of these questions around reconciling the individual dimensions of legal complaints with the collective dimensions. Or maybe that part of the decision wasn't your focus, but.
Well, I mean, it seems to me you put forward a very interesting idea. I don't know if I have anything more to say about it than that.
Yeah, I would say if you're talking from the community's perspective on the Aboriginal side of things, public understanding may be an interesting avenue, but I don't know that it really solves our internal dilemma around how we carry our rights. I would say then it was kind of interesting how there were a number of submissions about how that may happen, though the court ultimately just kept writing, I think 3, maybe 4 times in there. This is something that's really important, but we don't have to decide that because this is all about abusive process, which I found also intriguing that the other times we use abusive process, we're accusing the Ben family of trying to protect their trap line as being abusive because as trappers they should have known judicial review through their chief and counsel was the right way to go. Oops. So, I don't know. It may well be helpful. It may be helpful for sort of larger organizations like, I don't know more, and I hesitate to use the word organization, but gatherings, where we're not specifically linked to a particular community or a traditional territory. So in that case, maybe it will be helpful. I don't think inside the communities themselves, though, that it's going to be a resolution to who can assert the rights, which is probably more of a question for internal discussion than the courts.
Maybe just building off that question a little bit, I'd be interested to hear what you thought of the discussion of identity in Chilcotin Nation. And in particular, Justice Vickers seems to be very open to the idea that allegiances run through family and clan and nation. And he's not convinced by the province's argument that the correct rights holder lies in the band, in the Zenigwetan, and is willing to see the Chilcotin as the rights holder. So I just wondered if you'd speak a little bit to maybe an opening in Chilcotin to new forms of recognition of identity.
Is this on or? I think it's probably, I would say it's a question of fact depending on the community, on each community. Historically, what's the law on who is allowed to represent that community, or what's the appropriate unit of community to be asserting rights? And I think I think it's good that there's an acknowledgement of that in Chilcotin. But I think it's good that there's these plurality of ways of approaching the question, and I haven't really perceived it as being closed off to only sort of chief and counsel as the appropriate rights holder in all cases. I think it's more of a factual inquiry depending on the case.
I think I would certainly agree with that. We have counsel with the Aboriginal litigation group at the Attorney General's office, and we certainly have quite a few actions or claims in the office which are brought by traditional Aboriginal organizations, as well as claims that are brought by Indian Act bands. And we have actions which are brought on a representative basis by individuals. Sometimes those individuals will be chief and council members, but not in every instance. For example, in the Keewatin case, they were community members who were not on the chief and council. And in that case, there was a representation order which was made by the court. And it was based on evidence. So in each case, it's sort of a fact by fact, a factual determination, I think. We have quite a few First Nations in the province where there is only the one government, the Indian Act band government. And there are others where we have perhaps a traditional government coexisting together with an Indian Act band. And there is always the question in those cases as to who you consult with, who is the rights bearer. But it is, I think, a factual issue. It needs to be determined on a case-by-case basis.
My name is Mike Esri, and I'm with the Department of Justice in Toronto. Professor Slattery, I'm curious, the limitations issue that came up in the Métis case had already been canvassed by the Supreme Court in Wawayekum a few years earlier. The court seems to have come to an opposite decision this time around. Is there room to reconcile those two, to understand the difference between them?
Yes, I think there is. In Manitoba Métis Federation, of course, both the majority and the minority refer explicitly to the case you mentioned, which deals with fiduciary responsibilities of the Crown, where the court held that statutes of limitations would operate to effectively exclude actions which were out of time. The court seems to say two things. One is that in the Manitoba Métis Federation case, the claimants were seeking a declaration as opposed to some form of personal relief or damages or land or something akin to that. So that seems to be a point of distinction that they're resting on. The other is that they seem to suggest that the way in which the doctrine of the honor of the Crown operates depends upon the specific context. And when it's operating in a context where the Crown has assumed responsibility over specific Aboriginal interests or lands, the way in which the doctrine operates may not exclude statutes of limitation. But when one is seeking a declaration in relation to a matter of high constitutional import, statutes of limitations cannot exclude or prevent a court from ruling on the constitutionality of Crown conduct. Now, the court doesn't say that as explicitly as I'm putting it to you, but it seems to me it says it reasonably clearly. And I think, to give Justice Rothstein credit, of course, he does zero in on this, and he does point to an apparent discrepancy. I'm inclined to think that the discrepancy is a little more apparent than real, that actually these are two rather different cases, and in particular, if you just want to rest on the difference between a declaration and personal relief, that could be distinction enough.
Here, before we thank our panel, Sonia, do you have anything to direct us to?
Yeah, so I just want to remind you that our keynote speakers in the room, and the keynote is actually starting at 1:30. So we'll go downstairs, eat lunch the way we do on a regular workday, fast, and then